make me sick. I'll call Tembela to come and get my stuff from your two-timing S. I really hope these whores who make you happy, I really hope these whores make you happy and have fun telling your daughter how you fucking cheated on a woman who was nothing but nice to all your family. I'm gonna go for my blood test tomorrow morning. You better pray you did not give me anything. So she suspected that she might have picked up some AIDS from this person because he was involved with 3 other women, which she discovered late this year, late last year. Now that is the first thing, the nature and history of the relationship between the two of them. It started in 2006, we said. The second aspect dealt with by counsel for the state is the accused's alcohol intake and state of sobriety. The accused contradicted herself on the amount of alcohol she consumed on the night of the incident. This is so about her intake of Hunter's Dry and some tequila shots. She is falsely trying to understate the amount of alcohol she consumed at the sense. The undisputed evidence of Masego is that accused additionally also consumed at least 2 cocktails. Originally, accused acknowledged this fact, but during cross-examination, she raised a dispute. The accused also disputed Chauke's and Masego's evidence that she not only participated in the smoking of a dacha joint, but also that she was drunk. It was never put to the Chauke and Masego that it was only the deceased that smoked the joint, even on 2 different occasions, as accused testified. Counsel submits that the accused attempted to put herself in a good light whilst trying to put the deceased in a bad light. Bear in mind what I'm reading is what the state said. It's submissions by counsel for the state. Thirdly, as far as the dancing incident at the club, counsel for the state says the accused falsely attempted to deny, firstly, that she knows the deceased ex-girlfriend called Kia. Secondly, that Kia came and danced in deceased's presence. Thirdly, that she, the accused, was seriously upset about the incident. She denied that. Further, that the accused was irritated and seriously upset by the incident was testified to by Chauke and Masego, who were corroborated by Luyanda Sulupa, that during the argument between accused and deceased in the bedroom, the name Kia and Mpo were mentioned. Then, as far as the fourth aspect is concerned, that is the incident with the 2 gentlemen, counsel for the state says the accused was, during her testimony, at pains to paint the deceased as the over-jealous and aggressive boyfriend. The accused version that it was because of this incident that the deceased insisted that they leave the sands ought to be rejected, because Chauke and Masego testified that they had all decided to leave at that time and were in the process of leaving when this incident occurred. Regarding the incident in the parking lot, counsel for the state submits that the fact that the accused did not want to leave with the deceased from the sands was not because the deceased's behavior with the 2 gentlemen, but it was because the accused was upset about the incident with Kia. Further, it says counsel submits that Counsel further submitted that any attempts by the deceased to convince the accused to come home was not aggressive, but it was merely persuasive in nature. This is borne out by the corroborative evidence of Chauke and Masego that the deceased was not aggressive towards the accused. Although still upset about Kia's incident, accused was persuaded at some stage to go home with the deceased. Besides, accused never informed Chauke, her longtime friend, or Masego, that she was being forced by the accused against her will to go home with him. The accused's phone calls were not as a result of her fear of the deceased, but as a result of her unhappiness and anger following her jealousy that followed the dancing incident with Kia. That is why she failed either to inform Chauke or Masego in the vehicle or Mpo and Tapelo at the house that she is being forced against her will to go with the deceased. Now, regarding the deceased's physical location when the bedroom door was unlocked, according to the testimonies of Mpo and Tapelo, the deceased was still outside the window in the entertainment area when the bedroom door was unlocked by the accused. This is in contradiction to the evidence of the accused that the deceased was standing at the door busy fidgeting with it at the time she unlocked it, and that the deceased pushed it forcefully, that she was thrown onto the floor. Her evidence on this aspect is inherently improbable, counsel for the state submitted. As far as how the knife came to be in the bedroom, counsel for the state submitted that, argued and contended that the accused suggested that the deceased used the knife to fidget with the door's lock and that he subsequently brought the knife into the room. This is controverted by the evidence of both Mpo and Tapelo, that when the door was unlocked by the accused, the deceased was still outside the bedroom's window. Also, both of them never observed a knife in the hands of the deceased while he was with them in the entertainment area. According to Luyanda Sulupa, there was an occasion when he heard the door of the bedroom open, something like a bag being thrown onto the floor, and a person returning into the bedroom later. Counsel submits that this incident explains that the accused had an opportunity to fetch the steak knife from the kitchen and return with it after she was requested by the deceased to leave the room. According to counsel, this indicates premeditation by the accused to cause harm to the deceased. Also, the fact that McDonald's food, which was brought by the accused into the house, ended up in the kitchen fridge is indicative that the accused is the one who put it in the fridge, and in so doing had the ideal opportunity to take possession of the knife. Now, as far as the deceased's change of mind as to whether the accused should leave the room or not, counsel for the state submitted that in terms of the accused's testimony, she was at some stage instructed by the deceased to get out of the room or the house. The deceased even started packing her stuff into a bag to carry out this instruction. The deceased thereupon inexplicably changed his mind and physically prevented the accused from leaving. Counsel submits that the accused version in this regard is inherently improbable, more particularly if one takes Luyanda Sulupa's account about the hearing, the door being opened and something thrown onto the floor, and seeing a bag lying outside the room on the floor. Regarding the accused being stabbed on the stomach by the deceased, counsel for the state submitted and argued that the accused testified that the deceased had pinned both her hands with one of his hands. Deceased then let go the hands and attempted to stab her. This is improbable. Why he would have let go her hands and only then attempted to stab her is inexplicable. Secondly, she testified that she was fighting with the deceased when he was busy stabbing her on the stomach. What is strange and improbable is that despite her efforts to prevent the deceased from stabbing her, she did not sustain any injury to her arms or hands. Thirdly, the 5 stab wounds were all located in a minute area of 4 centimeters of her stomach. Counsel submits that the extremely close grouping of the injuries is indicative of the fact that they were not sustained during a violent physical fight, but were rather the result of a later attempt by the accused herself to mutilate herself or to commit suicide. Besides, the relative minor and insignificant nature of the injuries, mostly of them superficial, further strengthens the inference that it was not the direct result of a violent attack by the deceased, but rather that they were self-inflicted by the accused herself. The accused testified that she was in a state of shock after the incident and not in her right state of mind. She went as far as breaking a bottle so as to slash her wrist. It was only through police intervention that she did not succeed with her suicide attempt. Counsel submits that the 5 abdominal stab wounds were therefore self-inflicted under the circumstances, and this is a reasonable inference. Counsel for the state further argues that Dr. Lucozzi's outright dismissal of the possibility that the abdominal wounds of the accused could have been caused by a broken piece of glass without having seen or examined the particular piece of glass seems disingenuous. Lastly, it further more seems improbable that if the accused was stabbed by the deceased on the stomach, she would fail to mention it to anyone at the scene or to the investigating officer when he interviewed her. As far as the accused disarming the deceased as they were wrestling for possession of a knife, this is where the accused version became bizarre and outrageous. Her version, on the one hand, was that the deceased was strong enough to hold both her hands above her head with one of his hands, such that she was unable to loosen her hands. On the other hand, she stated that she was able to wrestle the knife from the deceased hand. Accused version is inherently improbable when viewed in the context of the following. Firstly, that the deceased was obviously much stronger than the accused. Secondly, that the deceased held the knife in his right hand, which was presumably his stronger hand. Thirdly, that the deceased held the knife at the handle with only the sharpened blade protruding. In these circumstances, in a presumably violent fight for the possession of the knife, counsel submits that it is totally improbable, if not outrightly impossible, that neither the deceased nor the accused was injured in any manner whatsoever. As far as the accused escape from under the deceased, counsel submitted that the deceased was 1.83 meters in height and weighed approximately 110 kilograms. The accused, in contrast, is substantially smaller in build, weighing only 64 kilograms and being only 1.68 meters in height. The explanation by accused as to how she escaped from underneath the deceased can simply not be true. It seems improbable that the accused, having succeeded in disarming the deceased, did not stab the deceased immediately in an attempt to free herself from under him. The accused was lying on her back on the bed, and the deceased was sitting on her legs. She said the deceased did not suffer any injuries when he pushed him, despite the fact that she had the knife in her hand when she pushed the deceased. As far as the deceased preventing her escape from the room, counsel for the state submitted that how the deceased was able to regain his balance and to get off the bed, turn around and start rushing to the door, and succeeded to catch up with the accused in a few steps before she reached the door is not explained by the accused. Her version on this aspect should also be dismissed because the deceased, according to her, was still on the mattress at the time she got up from the bed. On the accused's own version, as she got up, she was already facing the door and immediately started running towards it. The deceased, on the other hand, on the contrary, was facing away from the door. As far as the way the accused was facing at the time of the stabbing is concerned, counsel submits that the accused is contradicting herself in respect of what happened shortly before the stabbing. The accused testified that the deceased caught up with her before she reached the door. He then turned her around. She was facing the bed and the deceased was facing the door. However, when cross-examined on this aspect, accused changed her version to the effect that her back was facing the bed and deceased's back was facing the door. She also retracted the version that she was turned around, and stated that she was not turned around. She came with a new version to the effect that it was the deceased who turned around, as the record would show. And lastly, as far as whether the accused screamed for help inside the room is concerned, counsel submitted that Luyanda Sulupa denied hearing any screams for help whilst the accused was still inside the room. Her version that she did scream was only proffered in cross-examination, and it is submitted that it should be rejected as false. Counsel for the state, then after discussing those 14 points, concluded that by stating that in the light of the inordinate number and material nature of improbabilities in accused version, that she acted in private defense, it is submitted that it cannot be sustained and that it should be rejected as false beyond reasonable doubt. That was the end of the submissions which were made by the state. Then there were contentions and argument by the counsel for the accused. The counsel for the defense argued and contended on behalf of the accused by dealing with aspects of the matter under the headings evaluation of evidence and the burden of proof of his heads of argument for the accused. In this part of his argument, counsel commenced by referring the court to several cases as authority for the way in which the court should approach the evidence where it is faced with two conflicting, in some instances, materially destructive versions. These cases are the following: State versus Ntsele, 1998, Volume 2, SACR 178, SCA at 182B to F, and State versus Singh, 1975, Volume 1, SA 227N for Natal, and State versus Hadebe, 1991, Volume 2, SACR 166T at 167J to 168H, then Rex versus D. Ford, 1937 AD 370 at 373. These cases also deal with the burden of proof in circumstances. The burden of proof in criminal cases. It is counsel's submission that there is, firstly, valid criticism to be leveled against the evidence of the state witnesses, and accordingly the court cannot downplay the negative significance of the material contradictions in the state's case in the following respects. Firstly, the alleged state of sobriety of the accused and that of Masego at the time they left the club. Secondly, the conduct of the deceased upon arrival at home before and after he discovered that he had been locked out by the accused. And thirdly, the nature and content of the exchange between the accused and the deceased after the deceased entered the bedroom, before the accused ran out, later screaming for help. Fourthly, the nature, location and extent of injury on the accused. Fifthly, the type of clothing and its state which the accused was wearing on her upper body throughout the morning of the incident until she was taken away by the police. The only other aspect on which the state witnesses who were in the house agree upon is the exclamation by the deceased that the accused and had stabbed him. That is when he said, "This bitch has stabbed me," seemingly implicating the accused. Counsel submits that reliance by the court on their account will be rather treacherous and a serious misdirection. Counsel for the defense further submits that there ought to be doubt in the mind of the court as to the ability and opportunity and the presence of mind on the state witnesses to give a reliable account more favorable and preferable than that of the accused. The court must attach weight to the contradictions in the state's case and cannot simply reject them as immaterial. Counsel then submits that the version of the accused is reasonable and possibly true. After quoting what is stated in the cases of State versus Van der Meyden, Meyden, 1999, Volume 1, SACR 447W for Witwatersrand at 450A to B, and State versus Mtsweni, 1985, Volume 1, SALR 590 at 594B to D, and after referring to State versus Crossback, 2008, Volume 2, SACR 317 SCA at 157, counsel for the accused proceeded with his evaluation of the evidence by submitting that there is no onus that rests on the accused to prove her innocence, that she is only required to show that on a preponderance there is a reasonable possibility that her version could be free, regardless of whether the court subjectively believes her version or not. Also, that the body of evidence before the court overwhelmingly indicates the probabilities to be weighing favorably towards the version of the accused as the only plausible, as opposed to that of the state, which is largely based on conjecture and suspicion in the following respects. Firstly, the only reason why the accused would have called the cab is because she had decided she no longer wanted to be with the accused any further. Secondly, testimony of a cab driver and the cell phone records support this contention. There is no other explanation why the accused would then leave and ignore the cab driver's calls other than that provided by the accused. Thirdly, further, the accused's phone calls or phone records provided to the court indicate that attempts were made to get hold of her family on the way to Alexander and when she was in the bedroom without success. Fourthly, the accused would only have been prompted to change her mind and unlock the bedroom door because of the persistent determination to force her to do so by the deceased, and it is unlikely that he would have done so without kicking dust, as he said. Fifthly, counsel submits that on the evidence before court, the deceased would have had the opportunity to get the knife from the kitchen, and judging from his determination to be with the accused on that night, he would in all probability have attempted to jack the door lock open. Sixthly, as to precisely what happened inside the bedroom, the court only has the word of the accused against speculation and conjecture on the part of state witnesses, and that were at the house but not inside the deceased bedroom, not inside the deceased bedroom. In the seventh instance, the incontrovertible expert testimony and opinion of Dr. Lukosi supports the probabilities of the accused account of what happened behind that closed bedroom door. There is no reason, in fact, and in law, to dismiss it as unreliable. In the eighth instance, counsel concluded by submitting that the accused version is reasonably true in the circumstances and therefore ought to be accepted by the court. In his heads of argument, counsel, in the last instance, deals with a brief evaluation of private defense on the established facts and conducts his argument and concludes his argument by submitting that the accused should be found not guilty and should be discharged. And that, firstly, when considering the fact whether the death of the deceased was brought about due to unlawful and lawful conduct, an analysis of the evidence must be done with due regard to the legal principles crystallized in the cases he has referred to above. Secondly, that counsel submits that the court should not, as an armchair critic, sit back and, with the benefit of pedantic hindsight, enforce perfect conduct in the perfect world in order to determine reasonableness or lawfulness. In other words, as he says, enough said about the contentions on behalf of the accused. I now deal with self-defense and its requirements. The accused, having pleaded not guilty to having killed the deceased, and the basis of a plea being a private defense, what remains for this court to do is to analyze and evaluate accused private defense against the backdrop of the entire evidence heard by the court and to state its findings on accused intention and the lawfulness of her action when she exercised her private defense. Lest one forgets, a special word of thanks and indebtedness is hereby expressed by the court to both counsel for the state and for the witness, for the defense, for having submitted well-researched heads of argument which have definitely assisted the court to arrive at what it considers to be a true verdict. I have already referred and summarized the contents thereof. Accused private defense and its requirements. In our law, a person acts in private defense and her act is therefore lawful if she uses force to repel an unlawful attack which has commenced or is imminently threatening upon her or somebody else's life, bodily integrity, property, or other interest which deserves to be protected, provided the Defensive Act is necessary to protect the interest threatened and is directed against the attacker and is not more harmful than necessary to ward off the attack. In this regard, see Burchell J. and Milton J. Principles of Criminal Law, 3rd edition, 2005. Also De Wet and Swanepoel, Strafrecht, 4th edition, 1985, by De Wet J.C. The requirements of the attack are the following. The attack must be unlawful. In this regard, see State versus Goliath, 1972, Volume 3, SA, Volume 1, A for Appellate Division. Counsel for the defense submitted that the brutal assault to which the accused was exposed at the hands of the deceased had no justification whatsoever and therefore constituted unlawful conduct. Secondly, the attack must be directed at the interest which legally deserves to be protected. See Rex versus Van Vieren, 1961, Volume 3, SA 305E for Eastern District. Counsel for the defense rightly, in my view, stated that such interest can be life, bodily integrity, freedom of movement, or to prevent crimen injuria, but does not specify the interest in accused case. Thirdly, the attack must be imminent but not yet completed. See State versus Van Wyk, 1967, Volume 1, SA 488, Appellate Division, mentioned by counsel for the defense in the case of accused defense. The requirements of private defense are the following. A, the defense must be directed against the attacker. Counsel for the defense submitted that this requirement is as in the present matter before the court. B, the defensive attack must be necessary in order to protect the interests threatened. Counsel for the defense submitted that the action taken by the accused in the circumstances was the only way she could avert the threat to her rights or interests. C, there must be a reasonable relationship between the attack and the defensive attack. Counsel for the defense submits that it has been established on the uncontradicted version of the accused, and he leaves it there. D, the attacked person must be aware of the fact that she is acting in private defense. Counsel for the defense submitted that to this extent the accused has been unequivocal, and as is apparent from her testimony during the bail application and the subsequent trial. It is, however, necessary to point out that submissions and conclusions made on behalf of the accused are not the end of the story. There is still the outstanding question of exceeding the limits of private defense, which counsel for accused chose not to deal with. The critical question to be answered here is, did the accused under the circumstances exceed the limit of private defense? Did the accused under the circumstances exceed the limits of private defense? In our law, if the attack party exceeds the limit of private defense by, for example, causing more harm or injury to the attacker than is justified by the attack, she acts unlawfully. She then becomes the attacker herself. The test for exceeding the limits of private defense was formulated and spelled out in State versus Ntuli, 1975, Volume 1, SA 429-8A for Appellate Division, as follows, and I quote, if X, in brackets, the party who was originally attacked, is aware of the fact that her conduct is unlawful because it exceeds the bounds of private defense, and that it will result in a wise death, or if she subjectively foresees this possibility and reconciles herself to it, she acts with dolus intention, accompanied by awareness of unlawfulness, and is guilty of murder. I now deal with the findings on accused intention and unlawful action, unlawfulness of her actions. In my considered opinion, the question of accused intention to stab the deceased ought not to be in issue, because as the court record shows, the accused herself expressly admitted during cross-examination that she stabbed the deceased intentionally. If anything, there was premeditation in her stabbing. The deceased, for example, for stabbing the deceased. For example, the accused was asked, you said that you stabbed him in order to get away from him. And she answered affirmatively by saying yes. And I now quote from the record itself verbatim here. The accused had just succeeded in getting the knife from the hand of the deceased, and she was asked, and why did you not stab him then? And she answered, because I was trying to get him to leave me alone. Like, by then I saw that he does not want to leave me alone. That is why I had to push and stab him, to get away from him. I kept on telling him, you are hurting me. Nguli, you are hurting me. Stop it. What is going on? Like, you are hurting me. Leave me alone. But he would not leave me alone. So that is why I had to, like, push and stab him in order that he can leave and I can get out. She was then asked, at the time you executed that push action, did you foresee the possibility that you are going to stab him in that action? And she answered, yeah, I wanted to stab him. I did want to stab him. I stabbed him so that he can get away from me. I did not know where it would land. I just wanted to get away from him, to get away from me, so that I can get out before he can kill me and hurt me even more. He was, in the third instance, asked, you said you stabbed him in order to get away from him. So you intention, and she answered, yes. You said you stabbed him in order to get away from him. She answered, yes. So you intentionally stabbed him. She said, I did, so I can get out. And she was asked, and holding the knife as you did, you foresaw that the knife will enter the chest and make even enter his heart? And she answered, Sir, I'm not a doctor. I would not have foreseen where the knife would end. I just wanted to hurt him so that he can move away from him, get a bit of a distraction, and I can go out. I did not plan for it to go into the heart. She was then asked, Madam, if you stab somebody in the chest, is there a possibility that you may hit the heart? And she said, I did not plan to stab him in the chest. I was pushing him away from me. The knife was in my hand. I wanted to hurt him so that he moves away from me. Madam, listen to the question. If you stab somebody in the chest, is there a possibility that you may hit the heart? Then she answered, there is a possibility, but the chest is thick. And then the prosecutor said, you are right, but you know that there is that possibility. And she admitted that there is that possibility. And you know you can hit the lungs. And she said, there is also that possibility too. Now, in the last instance, Mrs. Skete asked her, Madam, but on your own version, you stabbed him intentionally. And she answered expressly and said, I stabbed him intentionally. So, this is to be found in the court record at pages 81, 82, and 83/387. That's where you'll find what I've been quoting here. So that's why I argue here that as far as I'm concerned, it is my considered opinion that the question of intention should not be an issue, because the accused herself admitted it expressly under cross-examination, and this is what I've read out to you. Even if the accused believed that her life was in danger and that she was entitled to engage in a defensive attack, objectively viewed, the situation was not one in which she was justified in resorting to a defense. The defense must fail, and the private defender's killing is unlawful. See State versus Atwood, ATTWOOD, 1946 AD, 331-340. Also see State versus Ngomane, 1979 3 SA 859A for Appellate Division. You'll recall this is when her counsel argued that someone was going to come out of that bedroom in a body bag if the deceased had not been killed. So she believed her life was in danger. And according to the law, to the Atwood and to the Ngomane case, she is not supposed to be the attacker herself, but once she attacks and kills the other party, then her actions become unlawful. Now, that is the unlawfulness of her actions, and I've talked about her intention. I come to heading number 12, which is the last heading, conclusion and order. On the authority of the Atwood and the Ngomane cases, supra, and having applied my mind not only to the merits and demerits of the evidence of the state and defense witnesses, but also to the probabilities and improbabilities of the evidence in its totality, I am convinced that the version of the accused is not reasonably possibly true, and that it has to be rejected by the court as false. more particularly in that there is no reasonable relationship between the deceased's alleged attack and the defensive action of the accused. There is no relationship. Stated otherwise, the court finds that the accused, in her private defense, which is the basis of her plea, exceeded the limits of or bounds of such defense by plunging the steak knife into the chest of the deceased, thus intentionally and unlawfully killing him. This lends credence to the evidence of the forensic pathologist Dr. Thandi Mahuluhulu that the nature of the force used for the type of injury sustained by the deceased was consistent with considerable force, which fractured the left fourth rib and penetrated the pericardial sac and right ventricles in the heart of the deceased. This unlawful act of the accused was accompanied by an express intention which is even recorded in the court's record. It follows that private defense cannot avail the accused. Also, she has exceeded its limit, as she had exceeded its limits, and I also find that the state has proved its case beyond reasonable doubt. In the result, I make the following order. The accused is hereby found guilty of the murder of Mr. Habedi as charged. That concludes the judgment. Yeah. Do you want to address the court?
Yes, my lord. In respect of any previous convictions, the state does not prove any previous convictions.
There are no previous convictions.
That's correct.
Right. Yeah. Is that her SAP 69?
That's correct, my lord.
Right. Are you ready to argue aggravating circumstances in the case for purposes of sentence?
My lord, I haven't yet discussed the matter with my college. I don't know whether they wish to give any evidence in respect of sentence, my lord.
This case has been set down for 2 days, today and tomorrow. And Friday is the last day of term. So we've got to go on tomorrow morning.
Yes, indeed. The state is prepared to proceed with the matter, my lord. I just indicated that I'm not aware what the situation is in respect of the defense, whether they wish to give evidence.
Yeah, but Mr. Makubela, I don't think he's here yet. And he hardly knows about the verdict. He will be here tomorrow. Then we can go on tomorrow. Thank you. The court adjourns.